Good evening. This is John Milburn for Laws 12060. This is trusts. We're into week 9, and tonight we're dealing with the issue of legality of trusts, which is based on chapter 22 of your text, or if you're using Del Pont, chapter 19. It's always a good idea to use both. Before we embark on tonight's topic per se, I want to digress for a moment and just talk about a thing called the Queensland Legislation Handbook. It's pretty old now, but it's still a valuable resource. Let me share the screen. I've got it up ready to go on my other screen, and you should see the legislation handbook. So this is readily available on a website, and it's through the Queensland government. You'll see that it's from 2004. However, it's a valuable resource in that it provides some commentary in relation to the executive and parliament. So it provides some detail about legislation, how it's introduced, why it's needed, how policy has an effect on the creation of a bill. It talks about the drafting process, the parliamentary process, royal assent, subordinate legislation, and this is really handy. Fundamental legislative principles, that might be something that you could use in an argument to support a claim that you make. So that's the glossary, the forward, and then we have the content, which expands on those areas of discussion. So keep that up your sleeve. It's the legislation handbook, and something that's often overlooked but might be useful. All right, so what I'm going to do now is stop the share. Before we started to record the session, we had a few questions about examinations, about the outline of submissions that you might prepare. And just briefly, without prejudicing those that have already submitted their work, and thank you for doing so, which I assume most of the people, if not everyone that has attending live, an outline of submissions is really an opportunity for you to talk directly to the presiding officer, the judge, presumably, to advance your claim as to why you believe in these facts, the application of the law should result in a certain outcome. So you're talking about the remedy that you seek, you're providing a commentary about the material facts, you're identifying the legal issues, you're applying the rules which appear through legislation or case law and coming to a conclusion. So if we go back to Introduction to Law, an outline of submissions looks very much like MIRAT or CIRAC or whatever, or IRAC, whichever one you chose, which of the acronyms that you like. So that's what it's really all about. Okay, so are there any general questions about examinations, about the assessment regime? Been a few questions about the exam on YouTube. Thank you, Melissa, for identifying something that I typed wrong on UCRU. Part A is in fact a problem-solving question, and Part B is a combination of essay and problems. So we'll talk more about that as we go through. Okay, if you want to ask a question, use the chat facility, or better still, unmute your microphone and address live. Okay, so tonight we're talking about legality of trusts. Last week we discussed the liability of parties to a trust, and this week we talk about legality. So the general principle that you would have seen adopted from English case law is that when it comes to dealing with a trust, the principle is that a trust whose purpose is contrary to public policy or illegal can't be enforced by a beneficiary. That's kind of the old blanket rule, which was adopted way back in the 18th century in Holman and Johnson. And the quote from that case was something to the effect that no court will lend its hand to a man who causes his action upon an immoral or illegal act. That's kind of the general principle. That's Holman and Johnson. But that principle is adopted more readily in England than it is in Australia. And you've probably read that in your notes. So what is the important thing that we need to identify at the start? Well, as we've talked about a number of times during the course, really the issue is for a beneficiary to bring something to the attention of a court. So we know that. So usually when it comes to dealing with an issue of illegality, it's more than likely the beneficiary that's coming to the court seeking something, probably a declaration, but it might be specific performance, or it might be a combination of those things, or it might be damages. In any event, the person who brings the matter to the court carries what's called the burden of proof. So I think we all know what the burden of proof is, don't we? Anyone tell me what the burden of proof is? Just to get you talking, a nice easy warm-up question. Yes, that's the degree. Yep, that's the degree to which a person has the onus of proof. But the burden of proof is really who has the responsibility for making the claim. And you're right, Erin, in a civil situation, that'll be on the balance of probabilities. So when we're talking about burden of proof, we're really talking about this tonight in the context of illegal purpose. Now, you might remember from our discussion on resulting trusts, a decision in the House of Lords called Chettiar and Chettiar. I don't know if that's the right pronunciation, but it's CHETTIAR against Chettiar, 1962, Appeal Court 294. Now, if you've got that case up on your screen, feel free to follow along or contribute. But in a nutshell, so we're talking about illegal trusts now. So in Chettiar and Chettiar, a father purchased land in the name of his son. He did that to avoid a statutory requirement. Because of the relationship of father and son, what's the presumption that would apply in those circumstances where the father purchased the land in the name of the son?
Advancement.
Advancement. That's the word I was after. A gift. Okay, so sure, in another world it would be a resulting trust, but in the world of father and son, it's a presumption of advancement. So therefore, if the father wanted to rebut the presumption of advancement, it would not be the beneficiary in that case who bears the burden of proof and the onus of proof, or the onus of proof if you like. So in coming to court, who's got the burden of proof on this occasion? The father or the son? What's it say?
The father.
The father, exactly.
The
Yep, the applicant. So the father comes to court and says, look, there might be a presumption of advancement, but I want to overcome that. I want to rebut that presumption by giving a proper explanation as to the nature of the transaction that led me to purchasing this land in the name of my son. Okay, the court says, give us a hint. Give us a hint as to what it is that you're going to say. Well, I did that so I could avoid a statutory requirement. Hang on. You can't say that, because if you say that, what you're really doing is leading evidence of a fraudulent purpose, that is to register the land in the son's name to deceive public administration. So you see how resulting trusts, presumption of advancement, and now illegal purpose can all wind into the same factual situation. So in that case, in 1962, the court said, because you would have to lead evidence of what is effectively a fraudulent purpose, we're not going to let you do it, and you're not going to lead that evidence, which means that the father's stuck with the presumption of advancement. The father loses. Does everyone follow that? Okay, so you can see that's the way in which the court adopted and applied the Holman and Johnson test in that case. Now I'm going to ask you to consider, by way of contrasting the result, not the underlying principle, but a contrasting result in Tinsley and Milligan. This was a 1994 decision, so we've moved on by almost 30 years now. Again, it's in England. It's 1994 One Appeal Case 340. So what happened in Tinsley and Milligan? In that case, a house was purchased by joint contributions of parties, and you've probably picked up on something already. In Chettiar, the father bought the property just in the name of the son. In Tinsley and Milligan, the house was purchased by joint contributions of the parties, whereas in the first one it was all one way. Anyway, what did the parties do? And they bought it jointly to facilitate the defendant's claim for social security benefits. So Tinsley now sought possession of the house. I should say the house was purchased with joint contributions, but the house was solely in Tinsley's name. Now, Tinsley wanted that house, the occupation of the house. What had happened is this. Milligan was Tinsley's partner. Milligan had been living there and Milligan had contributed to the purchase price, but the house was just in Tinsley's name. Now, why did they put the house just in Tinsley's name? They did that so they could claim more in social security benefits. So it's sounding a bit like an illegal purpose, doesn't it? So Milligan had at least formed the view that she'd been involved in a benefit fraud. She repented. It was a same-sex couple, and confessed to the benefit fraud, and Tinsley moved out. So Tinsley sought possession of the house and said, I'm solely entitled. The property is in my name. It doesn't matter if there's joint contributions. Milligan, who said, no, it was the common intention that the property should belong to both of them, and she didn't have to rely on illegality. She was able to rely on the common intention of the parties. Anyway, Milligan succeeded. She claimed a beneficial interest on resulting trust, and the court said, you're going to win based on resulting trust because you don't have to rely upon or lead evidence of any underlying illegal transaction. It's a fine line. And there's a couple of distinguishing features between Chettiar and Tinsley and Milligan. In Chettiar's case, the money was contributed entirely by the father, and there was a strong presumption of advancement to overcome. In Tinsley and Milligan, they both contributed, and the court heard the evidence that it was the common intention for both of them that the property should be jointly owned, in which case the court said, well, you can stop right there. We don't need to know why you did that. The common intention was enough for our purposes. Now, you might think, well, maybe you could have run that argument in Chettiar and Chettiar, but that didn't come through in the case. So in that situation, you want to see what the common intention was, and then if that's the end of the matter, then you don't have to go into the purpose. So even though I'm putting forward Tinsley and Milligan as a case that deals with illegality, it's not really, because the court didn't get that far. It's as if the court asked the question, did you both intend that the house should be owned by both of you? Yes? All right, that's all we need to know. We don't need to know why. So in Tinsley and Milligan, there was no presumption of advancement because of the relationship between the parties. And in Tinsley and Milligan, the illegality did not necessarily form part of Milligan's case in trying to recover that property. So strictly, Tinsley and Milligan didn't disturb the principle established in Holman and Johnson and applied in Chettiar and Chettiar. Are you still with me? Any questions? We'll have a little break while you digest that. Linda's saying, yes, I've got it. Anyone confused? I hope you're not, because I don't want to have to go through it again. All right, we're all good? Now, Tinsley and Milligan didn't disturb the Holman and Johnson principle. But in Australia, the courts have been much less willing to automatically apply the principle established in Holman and Johnson. What was the principle in Holman and Johnson? Can anyone tell me?
Basically, that no court will lend its aid to anyone who's found cause of action upon an immoral or illegal act.
Thank you, Erin. That's great. I'm pleased that you're able to tell me that straight away, seeing we did it just a moment ago. So that's it. All right. So in Australia, they don't necessarily apply that, not automatically anyway. So if there's evidence of illegal purpose, it's not going to automatically render the beneficiary's claim as unenforceable. So in Australia, generally, it's more flexible. And the court will look to see what the policy behind the law is that has been breached. That's part of why I showed you the legislation handbook, because, you know, we did issues in statutory interpretation where you go back and look at the second reading speech, etc. The same sort of thing here, but in a more general sense, that the court is looking to see what the policy behind the law is that's been breached. An example of how it worked in practice is Edmonds against Pickering, which was 1999, 75 SASR 407. Okay, so let's put it this way. The Australian courts have tried to soften the effect of strict compliance with the Holman and Johnson approach. In Perpetual Executors and Trustees Australia against Wright, this is way back in 1917, so that's Perpetual Executors against Wright, W-R-I-G-H-T, 1917, 23 CLR 185. The High Court considered a trust whose purpose was contrary to public policy or illegal. So if the Holman and Johnson approach had been strictly applied, the trust could not be enforced by a beneficiary. What happened in that case was this. So in Perpetual against Wright, while the wife was alive, the husband transferred property to his wife. Why did he do it? Well, it wasn't natural love and affection. It was because should he become bankrupt, it will be protected from the creditors. Kind of a familiar tactic. Anyway, the husband transfers the property to the wife. The wife passes away. No creditors have actually been defrauded because he didn't go bankrupt. And the husband said, well, I want my property back. And the court said, yeah, that's fine. Because even though your purpose was illegal, and my internet connection is unstable, so I hope this can continue. I hope we get there. Anyway, because the intention was illegal, it actually hadn't been carried into effect. So therefore, you can have your property back. I suspect in England, the result would have gone the other way. I suspect in England, they would have said, illegal purpose, Holman and Johnson, no, we're not even going to listen to what you say. A really good example is Nelson against Nelson, which is 1995, 184, CLR 538. So remember in Tinsley and Milligan, the house was purchased by joint contributions because one party wanted to claim social security. In Nelson against Nelson, the mother purchased all the funds for the purchase of a property, which is we'll call the first property, and she put that house, the first property, in the names of her children. So you with me so far? Mum buys a property, she puts up all the money, she puts it in the name of her children. What did she do? Well, she wanted to obtain a subsidised wall loan and she wanted to acquire a different property. We'll call that the second property. And she could do that if she didn't own a property previously. So she buys the second property, she doesn't disclose the first property, it's not in her name, it's in the children's name. Now, the evidence was, and this didn't come out in Chettier and Chettier, the evidence in Nelson and Nelson was, it was the common intention of all parties that her children should hold the first property upon trust for her. That was the common intention. That sounds a lot like what we were discussing in the case of Tinsley and Milligan, wasn't it? Okay, so in Nelson and Nelson, mum buys the property, puts it in the kid's name, goes and buys a second property, now wants her property back, the first property, because there's been a falling out. Who knows what happened in Nelson and Nelson? Who won?
The mother.
Mum?
The mother won.
Mum won.
Mother
Okay.
won.
All right. So the question.
And
yes, Brad?
sorry, and the order was subject to her repayment of the subsidy benefit back to the Defence Force before the trust would be created.
Very good. Excellent. All right. So the question in Nelson and Nelson was really this. So we know that we're arguing about a resulting trust, yes? Should that resulting trust be enforced? Notwithstanding that the person who sought to enforce it, which was mum, had done so to obtain a statutory benefit to which she was not otherwise entitled. And the court said, yep, fine, no problems. We're not really hung up on this Holman and Johnson principle too much. The legislation didn't disclose an intention that the deceitful purpose would be fatal to a trust. Sure, the legislation said this is not available to you if you own another property, but they didn't say anything about it being fatal to the existence of the resulting trust that would normally apply in relation to the first property. So the court found that the consequence of failing to enforce the resulting trust would be disproportionate to the mother's offence. Sure, she did the wrong thing, but we're not going to take her property off her. That's not fair. So refusing relief in that situation would provide a windfall to the children who had been party to the original illegal purpose. They knew all about it. There was that common intention. So I think that's an important fact as well. And as Brad said, and this is a really important part too, there's another aspect to this. In Nelson and Nelson, there were remedies available to the Commonwealth through the legislation, which meant that they could impose penalties. And that's a more appropriate response to what Nelson did than take her property from her. All right. Does anyone else have anything else that they want to say about Nelson? Yes, Brad?
I think I put there, in essence, the issue at hand for the court was deciding of whether resulting trust was the issue at hand for the court to decide, as opposed to the second property, which was essentially part of the remedy to satisfy the court's compliance with the legislation. So I'm sort of saying that, if someone bought a property in one name, effectively everyone said, yes, you're holding on trust, and then later on they say, no, you're not. That's not really related to the second offence as such. But I mean, the court have used, I think you said, I guess you're trying to explain the common intention rule, so I won't confuse it anymore. Sorry.
No, I actually really like what you're saying there and I hadn't actually thought of it in those terms, but you're quite right. The court is really there to determine the resulting trust on the first property. Why are we talking so much about what mum did in relation to the second property? That's a really good argument. Thank you, Brad. Any other comments, questions?
John, your internet is very unstable. It sounds like you've been on the bottle.
I haven't. I've been on a cup of tea, but not the bottle. Sorry, I don't know what to do about the internet here. Until we get the NBN, I'm almost at a loss. It drives me crazy. But can you hear me clearly? You can hear me enough? No big win in... Oh, yes. All right. So, look, what's another approach that we can do? Let's talk about repenting. So, in a claim for a resulting trust, the person who transfers the property pursuant to an illegal purpose may, despite that illegality, recover the property if they repent prior to the illegal purpose being carried out and the property remains identifiable. B says must have clean hands. Always a good term to keep in mind when you're dealing about equitable issues. Now, it's important that when I talk about repenting, I'm not talking about genuine remorse or contrition. It might be an element, but it's not necessarily what we're talking about. I'm really talking about simply whether the illegal purpose was carried into effect. Do you remember in Perpetual and Right, the illegal purpose wasn't carried into effect? So that was kind of an example of repenting. So in that case, the husband intended to defeat creditors should that be necessary. It didn't happen. It didn't come into effect. No creditors had in fact been defrauded as a result of the transfer, and therefore the court held that the transferor could recover the property because the illegal purpose had not been carried into effect. So that's kind of repenting through good fortune rather than necessarily any moral obligation. But what it means is that if you have a situation where you've somehow made good the situation, or the evil that might have been intended has not come into effect, then your claim on a resulting trust is going to be much stronger than it would be had the illegality actually meant something in reality. Now, does that make sense? Does anyone have any questions, comments? That's all good? All right. Looking at the chat facility, must have clean hands, yeah. Okay. Now let's talk about some of the interesting cases that relate to where people set up a trust, and in doing so, they try to restrain the actions of the beneficiary. One thing that people do is often in wills, they try to do this. I'm just playing around with the volume there. I hope that I'm coming through clearly enough. Okay, so let's look at some cases where the courts have said, no, what you're doing is invalid, it's void, we're not going to have a bar of it. So in Ree Johnson's Wills Trust from 1967, 1 All England 553, the court said, in terms of invalidity, the general proposition is that trusts which completely restrain someone from marrying or encouraging a person to divorce are void. So that's again the English approach, is sort of saying you've set up this trust, you've purported to restrain someone from marrying, or you've encouraged someone to divorce. We don't like it, it's void. Another example, this time an Australian example, is the trustees of church property of the Diocese of Newcastle against EBBECK, E-B-B-E-C-K. It's 1960 104 394. In that case, there was a partial restraint which forced a beneficiary to divorce, and the court said, we're not going to entertain anything which forces people to divorce or to not marry, and that's void. So there's a lot of public policy. B mentioned public policy, and there's a lot of that in it. So there come some of the examples where the courts have said, we don't like this, it's invalid, it's void, it's against public policy, we're not going to have a bar of it. But there are probably more cases where the courts have said, yeah, that's all right, we'll let it go. So let's go through some of those where the courts have said, it's okay, it's valid. It's not void. So the first is Lloyd against Lloyd. It's an old case from 1852. And a trust for a widow which ceases on their remarriage is valid. That's okay. You can do that. That restraint is okay. Trusts which prevent marriage of a person of a religious denomination or race or ethnicity, or a partial restraint on marriage, was held valid in an Australian case of Seidler against Schallhofer, 1982, to New South Wales, Law Reports at 80. A trust set up for someone on condition that he marries a woman of Jewish faith was upheld in Re Tux settlement in 1978. And a trust which demanded adherence or forbearance from a religious faith was held to be okay, and that's that EBBECK case. And finally, a gift of income coupled with an absolute gift to the testator's son at the end of the marriage with his present wife was held to be valid. That was Ramsey against the Trustees, Executors and Agency, 1948, 77 CLR 321. Now, that looks a lot like the case where Ree Johnson's will, where we said it's invalid. But in Ramsey, the testator's intention was only to prevent the wife from benefiting under the trust and not to separate the married couple. So in some circumstances, it's okay, but it's a very fine line. But generally speaking, the Australian courts have attempted to soften the view. Now, yes, Brad?
John, In that respect, it's quite common that if parents were to gift funds, we tell them to loan the funds with a minimal amount of interest, a nominal amount of interest payable each year, but repayable upon demand. So in the effect, if the parties separated, the loan is repayable back to the parents from the matrimonial pool.
That's not a bad tactic, and set it up properly through some sort of loan agreement and make it clear.
Yeah,
yep. So that's all designed to be protected in the event of divorce, no doubt, Brad. Okay, thank you. To see if there's any other. So Ramsey and Ellaway, yep, some of the cases we've talked about, and Ellaway on condition of divorcing husband. That's it. All right, thank you. But really, I have trouble in distinguishing some of these cases. So let's talk about Ellaway and Lawson, which was 2006, QSC 170. And I can see both Erin and B were onto this. You knew what I was going to say before I said it. So in Ellaway against Lawson, the court upheld a condition because it imposed no obligation on the daughter to divorce. So the question there was whether the condition was void against public policy by encouraging divorce, and the daughter appealed to the court for that finding so that she could take the gift without the condition. But the court said, no, the condition itself is not illegal or void. The will did not impose a condition on the daughter to divorce. But really, it's a fine line. And I do have trouble distinguishing that case from the principle established in Reed Johnson's will. Mind you, Reed Johnson's is an English case, and Ellaway and Lawson is an Australian case, although it is Supreme Court, it's not High Court. Yes.
Could I just ask, well, it's a question or a point in that. Do you think some bearing would be, John, that public policy might have softened a bit in regards to divorce and that type of thing from 1948 to 2006?
Actually, absolutely. It's not just a matter of England and Australia. I think you're absolutely right there, Linda. I think that there has been a general softening considerably. So I think that's a very, very important point. Thank you for that. All right. So let's move on to a slightly different topic, which is in relation to trusts that seek to restrain the transfer of property. So as a general rule, a disposition on a trust on a condition that the interest is not alienated, is transferred, is void against public policy. In other words, you can't give someone something and say, but you can't get rid of it. You can never sell it or deal with it. So generally that's void against public policy. So such a condition would normally be struck down entirely. But not every restraint, as opposed to a condition against alienation, is void. So courts don't like absolutes, but if it's conditional, it might be okay. So a partial restraint against alienation might be okay. Does anyone know what I mean by alienation of property? It means just getting rid of it.
Selling it. Yeah, selling it.
Yep, selling it or gifting it or transferring it or, just dealing with it, but removing it from you to somewhere else. Normally sale. Exactly. Thank you, B. So if we have a partial restraint on alienation, for example, a restriction on the transfer of the property to members of a specified class or for a short period of time, that might be valid. So attempts to lawfully avoid lawful obligations such as bankruptcy will be void if the attempts fall outside the realm of the trustees, the bankrupt's estate. Now, sometimes if a property has no value, then a clause restricting the alienation will be upheld as valid because in the event of bankruptcy, for example, that type of clause is not going to affect the rights of creditors because there's no value in the property. I'm not sure when that would ever actually come into play, but it's there. Now, I really hate to...
Sorry, can you say
Yes.
that again about the creditors? Can you
Yes.
say that again about the creditors?
Yep.
Yeah.
So, generally speaking, a condition that says that you cannot alienate property is void against public policy. But sometimes, if the property has no value, then such a clause restricting alienation will be held as valid. For example, in the event of bankruptcy, such a clause would have no adverse effect on creditors. And I must say that was about the best example I could come up with. So Brad talks about Section 120 exempts benefits to minors. Erin asked if there's a case. I don't have a case in mind for that, sorry. I couldn't see
What I
one.
was saying there, John, is
Yes, Brad?
if a future bankrupt had transferred funds to the direct benefit of the minors, insolvency specialists have told me it'd be probably something you would never bother to challenge pursuant to the Act, but because the benefit that was there for the minors and not to the benefit of the trustee, not to the benefit of the bankrupt.
Yes,
Directly.
true. And actually, that's a really good point. I will go through bankruptcy very soon, so we'll get to that shortly. All right, so the rule against perpetuities. Can anyone tell me what that rule is?
Basically, that you can't tie up property for a certain length of time, 80 years, I think it is, in Queensland.
Yep, so that's the rationale. Where's the 80 years come in? Where do we find that?
Property Law Act, isn't it?
Very good. Section 209 of the Property Law Act, 1974, Queensland, provides that a settlor can select a statutory period of time which does not exceed 80 years. And if there's no period up to 80 years prescribed, then the general law applies. And the general law is sort of complicated, but it talks about a trust where the perpetuity period extends to the lifetime of people alive at the date of creation of the trust and 21 years from the date of the death of the last survivor of those people. That is a life or life in being. And the hard part of always, how do you work that out? So drafters would choose an identifiable figure in order to identify a life in being. So the Queensland legislation said this is silly, way too complicated. Let's just make it 80 years, which is essentially Section 209 of the Property Law Act. But that doesn't apply to one very, very common and important trust, superannuation. So Section 434 of the Superannuation Industry Supervision Act, 1993, Commonwealth, says that perpetuities don't apply to that. Okay, so we're talking about trusts that provide...
No.
Yep, yes, Erin?
Sorry, John, what was that section again? Thanks.
Yep, Section 343 of the Superannuation Industry Supervision Act, 1993. And Brad said, because you must be a member and alive. Okay. Thank you. Yes, Brad?
But if you leave your benefit to minors via a child allocated pension, it could continue for the life, that benefit could continue for the life in the superannuation fund until the child deceases.
Okay, thank you. Now, we mentioned Bankruptcy Act. We're getting close. I just want to mention Bankruptcy Act, Corporations Act and Family Law Act, and then we're done for this evening. But let's talk about the Bankruptcy Act first. So the Bankruptcy Act provides, of course, for circumstances where a trust is void as against the trustee in bankruptcy in some circumstances. The main one is if it's created for the purpose of avoiding creditors, then it will be void against the trustee in bankruptcy. That means the trustee in bankruptcy can say, I don't care, I'm taking the property anyway. So the key under the bankruptcy legislation, to the extent to which the trustee in bankruptcy can attack transactions, is very broad, and the phraseology is applied to what's called an act of bankruptcy. So an act of bankruptcy includes making a disposition by a settlor that would render the property void as against a trustee in bankruptcy. There's a lot of words there. Have a look at section 40 of the Bankruptcy Act. Also, as Brad pointed out, have a look at section 120 of the Bankruptcy Act, and that provides that a transfer by a person who later becomes bankrupt to another person is void against the trustee in bankruptcy in some circumstances. So if the transfer took place in a period beginning 5 years before the commencement of the bankruptcy, and bankruptcy commences upon the act of the bankruptcy, and there was no consideration for the transfer, then the trustee in bankruptcy can attack that transaction and recover the property. Up to 5 years. So void really means voidable, in that the trustee in bankruptcy must take positive steps to bring the section into effect. And the section talks about payment of an amount equal to the value of the consideration. So, you know, a transfer for $1 is sort of caught up in that provision as well. So section 121 is another provision to look at in the Bankruptcy Act, and it provides that a transfer of property by a person who later becomes bankrupt is void against the trustee in bankruptcy if the property would probably have become part of the bankrupt estate if it hadn't been transferred, and the main purpose of the transfer was to prevent the transferred property from becoming divisible against the creditors, or to hinder or delay the process. So section 121 is very broad in its application, but it has the effect of enabling the trustee in bankruptcy to attack a wide range of transactions. So they're the sections to look at in the Bankruptcy Act. Corporations Act, have a look at Part 5.7b, which deals with what we call voidable transactions in insolvent situations regarding a company. So the transaction entered into by the company is voidable if the insolvent transaction during the last 6 months ended on the relation back day. So it's voidable if it's an insolvent transaction and an uncommercial transaction, and it was entered into 2 years ending on the relation back day. An insolvent transaction to which a party is to which a related entity is a party during the last 4 years is able to be attacked, and there's a really long period of 10 years that applies to an insolvent transaction entered into for the purpose of defeating or delaying or interfering with the rights of creditors, if that occurred within 10 years of the relation back day. So that's why insolvency is a great area of practice if you get into that area, because you've got a lot to argue about, and potentially many transactions can be attacked by trustees in bankruptcies or liquidators on the basis of the relation back provisions of not only the Bankruptcy Act, but also in the case of insolvency for corporations, the Corporations Act. So have a look generally at Part 5.7b of the Corporations Act 2001, Commonwealth. Last one, another Commonwealth Act, Family Law Act 1975. Have a look at section 106 cap B, subsection 1, 106b1 of the Family Law Act, and that empowers the Family Law Court or the Family Court or the Federal Circuit Court to set aside or restrain the making of an instrument or disposition by or at the direction of a party to defeat creditors. So that section operates irrespective of the settlor's intentions. So when making an order, the court will always consider the property in the context of a bona fide purchaser or an innocent third party. I've done a lot of talking tonight. You've been really attentive. I look around at the screen and I see people actually taking notes and listening carefully and asking good questions and providing good commentary. Thank you. You've done well. Now, speaking of questions or commentary, do we have any?
Can I just check the exam? Someone said last week, 8th of June. I haven't looked on the exam timetable, but it keeps coming up saying exam week starts on the 12th. We special.
Yeah, I think it was brought forward. The information I received originally was the 12th would be the start of exam week, but I'm pretty sure it's the 8th. Does anyone have a
8th at 2 p.m.
8th at 2 p.m. Thank you, Linda.
Yeah, they seem to have moved the exam forward because equity is also the 9th of June.
No, I missed that, Maria. Sorry.
They seem to have moved a few exams a week forward because equity exam has also been moved to the 9th of June at 2 p.m.
All right. So you've got trusts on the 8th and equity on the 9th. Well, that'll be fun. Very good. Okay.
I have one question, John. In the review questions in the study guide, can you explain question 1? Why is it only C? Why is it only a gift conditional on the children only living with their father will be void? Why is it not any of the others?
I don't have the study guide with me. I'm sorry.
The others are putting...
Yeah. Sorry, Linda. I just don't have it handy. That's all. Does anyone have it handy, or do you want to read it out?
Yeah, I've got it handy. It's got, the question is, which of the following statements is most accurate? A gift conditional on the children only living with their guardian will be void. B, a gift conditional on the children only living with their mother will be void. C, a gift conditional on the children only living with their father will be void. Or D, a gift conditional on the children only living with their grandparents will be void. And the answer is C. Why is that?
The reason that I think it says that is because there's actually a case judgment mentioned in the notes there that actually refers to where it wasn't, it was void because they said that they had to live with the father. I don't believe that there's any other judgments that say the other.
Yeah,
I did read that. No.
No,
I know there was a case judgment for the father, but it doesn't mean you wouldn't win for the other, would it?
That's right. And I totally accept what Vivian said. Sorry, I didn't mean to, what you said didn't make sense, Vivian, but just I wonder why there's that clear discrimination between male and female. Any thoughts on that, Vivian? No.
How do you tell between a determinable interest and a condition subsequent?
Yeah,
because very often if it's a condition subsequent is void, you take the gift free of the condition. But if it's a determinable interest, would that be a condition precedent? Is that the same thing?
Yep. I think with the use of the word determinable, it suggests that one party needs to do something for it to take effect, whereas a condition subsequent can be an independent event. So a condition subsequent can be, you know, a certain thing happens on a certain day, and it may be outside the control of the parties. Whereas if it's determinable, it's almost like the word voidable, where someone needs to take some action. Perhaps that's the distinction. We can have a chat on that one about you, Crew. I think, have you asked a question on that, B?
Because you see, very often these restraint on marriages and all these restraint on religions, most of the time they also argue about whether it's a condition subsequent or a determinable interest, because if it's a precedent, then the person doesn't, the gift fails and it goes back to the creator. Whereas if it's a condition subsequent, then you take the gift free of the condition. So it seems quite important to determine which it is.
I'll have to give that some thought. Sorry, B. Anyone have any comments in relation to that distinction? Okay.
Would that be determined? Would that be determined on a case-by-case basis, though?
Well, yes, certainly it always would be, but I guess if I'm interpreting B's question correctly, it's a matter of how do you draw those distinctions? What do you look for in coming up with that overall distinction between the two? So I've proffered an idea, but I can't support it with any case law or further commentary. But I think it's an important distinction. Okay, and Vivian's put the question was in the study guide. Just checking it was in the study guide. Yep, and I think it was part of the specific decision in that case. All right, now I need to move across to a different subject. Thank you very much again for all your contributions, and please continue to ask questions through UCRU. We're getting some really good questions. I do have one favour to ask, and that is, I think you all know that I took on this course pretty late in the piece, so I had some writing to do and some bit of catch up. Thank you for being patient with me in that regard. We need to look at feedback. The big red button is there. It's important for the university, it's important for me. So please, if you've got 5 minutes to provide some feedback, I'd really appreciate it. And be honest, if you're not happy with the assessment regime or the notes or whatever, feel free to let us know. If you are happy, please tell us. Okay. If you haven't submitted your assignment, I better let you get back and finish it off. And if you have, thank you very much. I will mark the assignment during next week, and I won't release the results until at least Sunday week. So around about 10 or 11 days, typically you get your results back. The way I normally provide the results is to provide some audio comment, which you can access through Turnitin. Those of you that have worked with me in the past may be familiar with that process. I provide usually a breakdown of your marks with the class average, and sometimes an indication of the actual mark that was the best in the class. I don't say who it is, but I just say this was the best mark. Okay. All right, all good. Thank you for attendance. I'll end the meeting now, and we'll see you next time. Bye.